Thank you. Okay, there's a motion, and we'll ask the secretary to call the roll.
Motion is due pass to Senate Appropriations. Allen?
Aye.
Allen, aye. Anderson?
No.
Anderson, no. Hancock?
Aye.
Hancock, aye. Hertzberg?
Aye.
Hertzberg, aye. Liu? Liu, aye.
Okay, so that motion passes 4 votes to 1. Well, let's next hear AB 884, and I assume that folks will stay around for that too. I guess technically you should go back to your seats, and then we'll invite you back. I apologize. We're getting everyone some exercise today. Okay. Thank you, everyone, for that. And the discussion continues with this statutory aspect of the debate. We'll hear from Assemblymember Gordon, who will present AB 884.
Thank you, Mr. Chairman. And as I think has been well explained by this point, AB 884 is a companion measure to SCA 14. SCA 14 would place in our Constitution, if approved by the voters, the requirements relative to the 72-hour public review before final approval of legislation. It would also enshrine within the Constitution the requirement of the legislature to record and make available audiovisual recordings of each chamber and its decision-making committees. Although the California Constitution currently provides that the proceedings of each House and the committees thereof shall be open to the public, few Californians have the opportunity to attend our meetings. They're just not here when we are holding our proceedings. While SCA 14 would appropriately establish a constitutional requirement that the legislature create and make available audiovisual recordings of the proceedings, details are left to this statute. AB 1884 contains a statutory implementation detailing how the legislature would arrange for audiovisual recording in a way that provided clear distinction of how this would be accomplished, but done so in a manner that is technology neutral. First, the bill would reaffirm the constitutional requirement that proceedings of each House and its standing committees be recorded and made available. Second, once recorded, the bill would require Legislative Council to post all such recordings within 1 business day in a retrievable and perceivable format for public use for the entire biennial session and the following session. Third, for the longer term, the bill would require the Legislative Council to archive all such recordings for at least 20 years and make the recordings reasonably available to the public. Finally, the bill would repeal the prohibition of using recordings of legislating proceedings for political or commercial purposes and allow the use of such recordings for any lawful purpose without imposing any fee. What these measures do is fairly common sense. And I think what's one of the pieces that's important here is that these were carefully drafted to be technology neutral so that they can stand the test of time. And the last thing we'd want to do, I think, is to enshrine in our Constitution specific definitions of technology, knowing how rapidly technology changes. But they were also drafted to provide certainty that the public would have access, they would minimize ambiguity about that. And in the end, I believe that AB 884 would simply and appropriately narrow the distance between the legislative process, the lawmakers who serve here in Sacramento, and our citizens. And I respectfully ask for an aye vote.
Thank you, Senator. I appreciate your testimony. Are there folks here who want to testify in support? This is deja vu all over again. Nice to see you again.
Nice to see you too, Mr. Chair and members of the committee. Jim Ewart with the California Newspaper Publishers Association. And we are in support of AB 884. It would strike a provision in the law right now that prohibits the use of some of the recordings that are made for uses that we think may be unconstitutional. That is going to be litigated right now. But more importantly, would allow public access to the footage of all of the sessions and the committees. And with respect to whether the definition of committee is something that is a matter of ambiguity, there is some guidance in the Constitution for that. In Article 1, Section 3, there is a standard in subsection B2, which says that any statute, court rule in place at the time has to be interpreted broadly in favor of public access and narrowly when it limits public access. And so that's a standard that we think is appropriate in making that determination. Also, we have expressed one concern about the existing language simply because of where the bill has been amended. And it deals with the issue of copyright protection that the state could assert in this footage. Our concern is that even though the language states that there is public access to the footage, and it's clear, we think, that somehow, somewhere down the line, the state could assert that in its copyright interests, it could limit the public's use of that footage. And so we have talked to the author's office about that concern. We would like to see that addressed either by a declaration that this is going to be, that the materials in the section are in the public domain, and some affirmative statement indicating that the legislature does not intend to assert any copyright interest in these materials. And with that, we would fully support this measure. Thank you.
That certainly sounds reasonable. Okay, other folks here to testify in support or with ambiguity, perhaps?
Right. Commenting neutrality.
There you go.
Gavin Baker with California Common Cause. In the interest of time, won't reiterate what we said about the previous bill, but we have the same position on AB 884, neither in support nor opposition. We have some concerns about the bill as drafted, but we thank the author for bringing this forward. It's a very important conversation. We hope that the issues can be resolved and that a consensus solution will move forward.
Thank you.
Mr. Chair and members, I'm Trudy Schaefer, representing the League of Women Voters of California, and my statement is basically the same as what Mr. Baker said. We do have concerns. We've gone through the comparison chart that the authors of the two bills, of the constitutional amendment and the statute, made, and noted places where it does seem that there's either ambiguity or a need to strengthen. And so we look forward to further discussions about this.
Thank you. Thank you so much. Folks here to testify in opposition or raise concerns, here we go. All right, welcome back, gentlemen. Senator.
Proponent of the California Legislative Transparency Act. Just in quick response to a comment you heard just a moment ago, that the definition of a committee is clear, and to a degree there was ambiguity, it would be interpreted broadly in favor of public access. The actual code that was cited, or rather the actual article in the Constitution that was cited, is something known as the Sunshine Act of 2004, which interestingly came through this body with a 2/3 vote, but at the last minute, paragraph number 7 was added, which said it doesn't apply to the legislature. So it is, in fact, a good example of why we do not want to rely upon the rules or a statute when it comes to a question as important as to the public's right to have access to what happens in this building. And with that, I'll just quickly make a couple of comments, if I may. First, with regard to the proposed statute, as you heard, can be easily and readily repealed or amended. The Citizens Initiative provides a constitutional guarantee that the public will have access to audio-video recordings, and no such right is present in the legislature's SCA. Second, although this bill does strike the current language of Government Code Section 9026.5 respecting the use of legislative audio-video recordings, AB 884 provides that these recordings may be used for any lawful purpose, which differs from the initiative's use of the term of any legitimate purpose. We choose the term legitimate because of its broad interpretation regarding First Amendment rights. Let me give you an example or two of why this is so important. As just mentioned, Government Code Section 9026.5 makes it illegal, a crime, unlawful, for a citizen to use recordings of legislative hearings for purposes that represent core First Amendment speech and conduct, specifically commercial or political speech. Under this bill, a similar speech ban could be passed by this legislature, which would then define what was or wasn't lawful. So there's an easy way for this body to use that term lawful to write another such ban similar to the one that currently exists. Second, earlier this week, the Assembly passed a bill which was strongly opposed by the California Newspaper Publishers Association that gave the state copyright privileges over public records. If the legislature made such an assertion over legislative audio-video recordings, then free access could again be withheld, and such an act still would be lawful under the definition of lawful, which is what's included in AB 884. So this is no protection at all for a public's right. Not only is it not in the Constitution, but the language that's used is easily circumvented. And the third issue I want to make, and final issue I want to identify, is that while the initiative calls for a 20-year online access for recordings, AB 884 requires only the current and immediate past session to be available. And I simply can't understand the cause for such a restriction. Today, Ledge Council's website provides 24/7 internet access to anyone for every version of every bill that's been introduced by the legislature and every analysis of every bill dating back to the 1999 and 2000 session. And Ledge Council's legacy site allows the public to view every bill and every analysis going all the way back to 1993-94 session. Why would this legislature even contemplate limiting the public to only the immediate session and this current session, the immediate prior session? It does not make sense to me given what we understand is available and easily accomplished through technology.
I'm sorry, Senator, just to clarify, I believe at the bottom, so section 2A3, it says Legislative Council shall preserve and secure all recordings made pursuant to subdivision in electronic form and store them in an archive for not less than 20 years. They shall be reasonably available for use by the public in the medium in which the recording was originally made. Is that
Not available on the internet.
on the White website? Okay.
Correct. So the concept here is if you are living in San Diego or Yolo County and you want to know what your legislator said or did 4 years ago, 6 years ago, 8 years ago, or you're trying to study legislation and you want to pull up that video
Right.
to see exactly what happened.
So we need to expand the language of reasonably available for use to
Reasonably available for use could be to show up and, show your ID card and go in and then make handwritten notes as to what is present.
Sorry for the interruption.
It's not the same kind of broad constitutional protection
Yep.
that would be available to everyone, anywhere, at any time, free of
Understood.
cost.
Understood. Thank you. Thank you, Senator.
Of course.
Yeah.
And with that, I'll conclude my remarks. And again, just urge a no vote as this bill needs, I think, serious attention and work to some of these defects I've identified.
Thank
Respectfully.
you, Senator. I appreciate it. Dr. Munger.
Well, this is continuing the conversation between initiative proponents and the legislature. So again, let me say, we're here to learn. We're here to hear what's wrong with the CLTA and why anything that's being offered is an improvement. And if you can show it, we're here. We're also very interested in any flaws we have in the CLTA. So for example, the Honorable Mr. Itzberg said, the CLTA said, well, you have this problem. You refer to bills being in final form, and there's ambiguity as to exactly what that means. And I said, that is a very interesting comment, since it's exactly the same language which is currently in SCA 14. So if it's a problem for everybody, and we're very eager to hear what it is. All right, but going on to AB 884, we'd have nothing but praise for this legislature if this legislature volunteered using its present budget and its own rules to implement on its own some of the provisions in AB 884 concerning the recording that the legislature presently makes. For example, recording being made right now of this meeting might be posted on the internet, quote, within a business day, unquote, as this measure would have it, of the adjournment of this meeting. That is, that would be tomorrow. None of the May recordings of the meetings of this committee are posted yet on the internet, and we're now in the second week of June. So if you legislature, right, sorry, I looked at them 3 days ago and they weren't available. The legislature might even live stream its meetings and so make the recordings available on the internet with no delay at all. But you don't need laws to make these improvements. You could make them yourself now. Regarding AB 884, the fundamental objection is and remains that it attempts to do the impossible, to set regulations to preserve public access and free use of recordings against the will, if need be, of a legislature hostile to the whole idea, using a mere statute which that future hostile legislature could change at any time. There isn't any way to solve that problem. Now, I will emphasize we, the proponents, could solve that problem, because when we write something into a statute, we can specify it takes a vote of the people to change it. The legislature doesn't have that ability. We used it. When we put protections into our statutes, we put them where it takes a vote of the people to change. So while there are some protections in our statutes and some protections in this measure, understand with utmost clarity, ours takes a two-thirds vote takes a vote of the people to change. You could undo your statutes with a majority vote of the legislature. However, let's pass over that objection to the particular terms in AB 884. As written, they are weak and public access easily restricted while following the regulation's strict letter. As Senator Blakeslee observed, the regulations for the archive could be satisfied by a single office in Sacramento to which a person would have to travel to play a recording, the office perhaps permitting no freedom to copy, excerpt, or transmit all or any part of it. Could a court rule that such could not constitute, quote, public use, end quote, as 884 has it, if the legislature maintained the contrary? I don't think so. Before being archived, the recordings under AB 884 are to be, and I quote, retrievable in a perceivable format for public use, end quote. Even if this language guaranteed anyone could link to a state-owned website and view a recording at will on their own equipment, which this language does not, quote, public use, end quote, might again deny any person the ability to copy, excerpt, or transmit all or any part of a recording. In short, person-to-person circulation of content could be choked off, even if the language of AB 884, as written, were strictly followed. The CLTA, in contrast, guarantees that any person as well as the press may view recordings at will on the internet and copy, transmit, and use the recordings freely. That the recordings must be posted for a minimum of 20, not 2+ years, and that only a vote of the people and not a majority vote of the legislature could restrict access. Now, the Honorable Assembly Member mentioned that we don't want to be too specific about our technical terms we write into the Constitution. And we write in the term internet. And maybe in 20 years, there'll be some other way of allowing inexpensive, instantaneous computer-to-computer or person-to-person communication. I'm not worried about this. The Constitution manages to say freedom of the press shall not be abridged. We don't actually deal with ink dyes descending onto vellum anymore. As technology has moved from typewriters to word processors and so forth, the courts have been able to follow pretty well what you meant by freedom of the press, and we think that posting on the internet will follow, even if in 30 years we're doing it by hologram. All right. AB 884 is not going to go from its present form to something better than the CLTA, which I keep reiterating. I'm happy to work the legislature to come up with a composite bill. I'm still waiting for someone to point out something that is better than the CLTA. Still waiting. I hear lots of things they think are as good, but I haven't heard an argument yet they've got something that is better. I'm waiting to hear it. We request this committee to hold it so that further amendments will be subject to public comment and review by this committee. This is particularly important to do because, after all, the last amendment of AB 884 was a literal gut and amend, without one word or even the subject of the bill or its author being preserved. The public and this committee has literally no idea what is going to come next, and so I suggest you hold this bill in committee until we all do. Thank you very much.
Thank you. Okay. Yes.
Mr. Chairman, members, good afternoon. David Wolf
You can sit down.
with the Howard Jarvis Taxpayers Association, just again registering our opposition in light of the prior comments. Thank you.
Okay, thank you. Thank you, David. I mean, I know one of the things that is brought up is some of the cost concerns and trying to make sure that the CLTA doesn't end up creating perverse incentives associated with holding hearings in other parts of the state. As was mentioned by Senator Hertzberg, we've been doing a lot of hearings of our select committees and also standing committees all over the place. And I think we can all argue that's a really good thing. And the question is, how do we make sure we move forward together in a way that doesn't, disincentivize that activity? Because I think we can all agree that's a good thing. But I know that's one of the concerns that's there about CLTA. So the questions of the committee, I know Mr. Vice Chair probably has some things he wants to.
May we respond to your comments?
Yeah, absolutely, please. Yeah,
Want to handle costs?
okay,
Just
sure.
real quickly, this question of cost and a chilling effect on public dialogue, I think has been an interesting one to consider. We relied upon precedent, which is that responsibility to the legislature should be paid by the legislature, and that the people had already voted under Prop 140 that there should be a cap, so that obviously the legislature can award itself
Right.
unlimited funds. When we brought this measure forward to the Legislative Analyst's Office and sought to receive feedback as to the cost for the total implementation of everything you've heard, the total cost on an ongoing basis, according to LEO, is about $1 million a year of new costs, about $1 million. The current legislative budget is in the vicinity of $300 million. And this $1 million represents a small fraction of just this year's increase to that state appropriation limit. So the first comment I would make is that the notion that this would chill speech seems unlikely given the de minimis amount of money that's involved, and given the fact that when we sat down and looked at how easy it is now to get recording systems or to use existing recording systems, we found that this is a small fraction of the $1 million annual cost. So this should not be a chilling effect. And second, if we were to push this into the general fund, it would then directly compete with Health and Human Services, with education, with parks. And the next time there is a budget downturn, and having lived through the last one with you all sitting up there, I am keenly attuned to the terrible pressures that will be faced by this legislature. And if there is any desire to cut something that the legislature doesn't really want to do in favor of doing something, for example, that it does want to do in the general fund, this will be one of the first places that is cut. So we think it's important this funding come out of that dedicated amount of money that's used for the state legislature to run this operation, which is enshrined in the Constitution and is consistent with precedent. And that's the reason we took that approach.
And Senator, certainly as former minority leader, you know a lot more about the kind of internal budgeting of the legislature than I do. And I would think that, but I would think I know that there's a big portion of the budget that's sunk costs and that there's very little flexibility over. But this is just one of the many things that will presumably be part of the negotiations that you have with the authors and leadership as this negotiation proceeds. So are there other questions from the committee or thoughts or, yeah? Joel, did you? Yeah.
Well, just speaking to what former Senator Blakesley had spoken to, I mean, Mr. Chair, you and I have talked about fully funding elections and how difficult that's been. And we just recently were talking about fully funding the Secretary of State's database to ensure that we don't see dead people voting. So we're having difficulties funding that. I could see very easily that this act of transparency would also be put on the back burner. And I don't want to say that that when given the choice between providing for poor children's health care and food, and that these are easy decisions to choose that over. So in my mind, it makes perfectly good sense to take it from a budget that's guaranteed that perhaps we won't get a raise next year because we won't have the money because we're funding transparency. So I very much like the idea.
Except as you know, the raises are coming out of a totally different
Well,
Form
I
of,
know,
yeah.
but this sounded a lot better.
I know, right. That's why I wanted to check you on it, my dear friend.
But if that was coming out of the raised budget,
Hey, don't worry about it. Senator Anderson agreed not to take the money. Don't worry about that.
I always take the money. So, so one of the concerns I have is, right now in the Constitution, there's a public right for people to have access, and SCA 14 doesn't keep that public right going, and AB 884 couldn't possibly do it on a constitutional level, and I really think that's important that we protect the public right to know how their government's operating and to have these transparencies. And I'd like for you to address that, but the other part I'd like for you to address, if you wouldn't mind, and that is, I've been in the legislature, I think this is my 10th year I'm completing. I've seen these transparency bills time and time again, and they never get through the legislature. And I have a good feeling about AB 884, and it concerns me because it took an initiative to give legislators the clarity of thought of why this might be important to the people we represent. But because it's not a constitutional amendment, so there's no protection that the people can go back to. What would stop one party from changing this in the future? Since we've seen one party domination in California for a long time, and I personally hold myself accountable for that domination because I haven't been working hard enough. But could you address that?
Thank you, Senator. Let me preface some comments before getting directly to that point. And that is that I want to start by thanking the proponents. We wouldn't be here today. We wouldn't be having this discussion if you hadn't taken the actions that you have taken to bring this forward. There is, I believe, an opportunity here to perfect an effort at public transparency and the opportunity for public engagement. And I think that, if we work together, we can do this. And I'm very willing, Senator, to look at some of the elements of SB 884, work with Senator Wolk and the proponents to look at, are there some elements of this that ought to be moved into the Constitution that are currently in this statute? For example, I think that it would be very, very appropriate, and will advocate with the senator, that we look at this business of the requirement for a 24-hour posting of any recording. Currently, that's not in the constitutional amendment as proposed by the senator. It's here in the statute. I would like to see that reversed. I'd like to move that. So I think there are some steps that we can take that will provide greater assurance for the transparency through a constitutional amendment. My goal here is to make sure that in implementing the constitutional amendment, that the legislature would have flexibility around the issue of technology. And I come from the Silicon Valley, and that's kind of my main emphasis here. I actually, Dr. Munger, believe that there perhaps will be a day when our citizens can participate in these hearings through virtual reality, and we'd have a whole nother conversation going on if that were possible. I think there is a way to craft this so that any concern about the a statute being manipulated by some future legislature can be reduced to the point that it is de minimis, if non-existent. And I think that's something, candidly, we ought to strive for in a conversation and dialogue between this legislature and the proponents. As it relates to the length of time for maintaining archives, I also think that's something that we can further discuss. Earlier, my esteemed colleague, Senator Hertzberg, talked about lawyer language and talk. I think that perhaps the difference between lawful and legitimate is an area that the lawyers could explore. One of my concerns about the term legitimate as exists in the proponent's initiative, I'm a little concerned that that might be too vague and lead to a set of lawsuits in the future trying to define that word. If they feel that lawful is probably not the right word, maybe there is some place that we can land that that comes up with the right word. And achieves what I think we're trying to achieve here. And I guess finally, I think as it would relate to the issue of budget, I think that there is a way to craft this so that the Constitution mandates this activity of maintaining the records in a way that the legislature, should it prefer to use a general fund source, would be required to do so. So I think there's an option in this regard that can be further explored as we move forward. And I thank you for your comments and questions.
Thank you, Senator. Senator Hertzberg.
I won't take too much time because I took so much in the presentation, but I think, Dr. Munger, you really raised an interesting point. I hadn't looked at the language, I did read it, but I didn't recall with specificity the notion of the specific words I referenced. But there's one really big difference. If in fact the lawyers are correct that the word in final form have constitutional challenges or challenges with respect to your intent, our languages can be amended and yours can't. We're in the process of developing it, and if in fact we found the problem and we copied your language, Senator Wolk did, in an effort to try to get as much harmony as possible between the respective measures, and if in fact that we have seen so many times of measures that have been put on ballots that often have been incentivized election turnout, disincentivize turnout, all sorts of things that we've seen, but at the end of the day, they get overturned, you actually undermine confidence with the voters because they look at this and they say, God, I voted for this and now it's overturned, it's unconstitutional. There's a number of examples I'm sure that you know. So I just wanted to share that with you in the sense that if in fact that is a problem that needs to be discussed, this gives us a venue to do it, albeit late. Secondly, I just want to share my own personal observations, final point, on the budget pressures. And I understand the issue of what our constraints are, but I manage the budget of part of this legislative branch for some period of time in a number of different capacities in which I was involved. I know when it means taking the sergeants to a meeting and what does it cost and what the line items are and what the other associated costs are. I know the games that get played internally and how that happens, and you do not want to have a chilling effect. I think there is internally, in terms of the realistic operations and management of this institution, ways to actually achieve the balance that Assemblymember Gordon was talking about, that gives you that flexibility but make sure there's not too much pressure. You know, we had a significant budget down to problem here last year, and you know, with a lot of people being laid off and a lot of other stuff. There were a number of issues that are very realistic. And all I'm just saying is these are things that I think that, again, albeit late, but can be drafted that achieves the deliverables that both sides need in order to create a legislation and or constitutional amendment, as the case may be, to achieve the end we all desire.
May I respond to your first part of your remark?
Yeah.
Thank you. Of course, I certainly share your disinclination to write initiatives which wind up in courts. I did before I came here, I, of course, listened to your meetings of a month ago, and I was very pleased to hear the praise for redistricting reform and how important it was that this be extended to local races such as in San Diego and Los Angeles. Well, having had a large role in writing that very reform, I will tell you, went to the California Supreme Court on that one, actually against my own party, as it happens, which is one of life's great ironies. And it upheld our language 7-0, ZAP, because the person who wrote that was Dan Kolke, who you may remember was the Governor Wilson's chief advisor. He's an appellate court judge, one of the most noted constitutional scholars in the area. I've been to the U.S. Supreme Court last year on redistricting, indirectly, because I was in amicus brief on the case concerning the Arizona redistricting commissions. And not as overwhelmingly, we won that case too. I'm pretty confident, therefore, that when we come up with constitutional language, there may be a slight argument among constitutional scholars somewhere, because there's always an argument about anything whenever there's real power that's at stake, depending which side you come down. We've been very careful with this one. I am happy to volunteer on Mr. Kolke's services with whatever counsel the legislature wishes to have on precisely these constitutional issues, to have a meeting of minds. And if indeed there is better constitutional language, and if there's a sufficient difference that there might be, and if we come to agreement on other things, then by all means, let's do it slightly better than slightly worse. But it's, to my mind, by no means proven that there's a flaw in the constitutional language that we wrote. But I'm perfectly willing to entertain the possibility that there is. Again, I'm here to say, find me the flaw in the CTLA, and you've got a really good case for the legislature putting on a bill that's mostly the CTLA, but doesn't contain the flaw. But I haven't heard that yet. And I will also remark in terms about things going forward, as I'd be, if there is no flaw in the CTLA and we want a conversation, I didn't put in that you should live stream your meetings, because I thought that might be a technical bridge too far to force on a recalcitrant legislature that somehow was going to live stream all of its meetings. But a legislature that's volunteering to take that on its own shoulders, I'm all for it. I gave you 72 hours. I think all of you have profited by having more than 72 hours to review some complicated bills. How thick is the budget? How thick are constitutional amendments, et cetera, et cetera? And if you would like to say that on at least some bills, perhaps more than 72 hours is appropriate, that's a strengthening. I think that's a big step in the right direction. And if you would like to say with your own recordings, this one is lovely, but as far as I know, it's broadcast only in English. And if you would like to see that they get transcribed into English text for the benefit of the deaf, if you would like to translate them into Spanish or Mandarin or anything else, if you would like to make them searchable so people don't have to play through the entire tape to sort of find out where someone was speaking, but just jump to the last silly thing Mr. Munger just said, I think that would be great. We didn't lay those burdens upon you, but if you would like to lay them on yourselves, we've thought a lot about those issues. We're happy to work with you.
Thank you, Dr. Munger. Are there other questions or comments from the committee? Yes, Mr. Vice Chair.
I just have one other. So in the CTLA, it talks about.
It's CLTA, by the way, I believe, right? This is.
Did I transpose them?
Well, both of you.
Might be me. Sorry.
Yeah.
It was. This is why it'd be very good to have it in writing. So the CTLA grants rights of any person to record a public proceeding and broadcast or otherwise transmit it. In AB 884, there is no such permission. So is that something you were thinking about adding, or why didn't you include it to start with?
I think twofold. One, certainly believe that if we implement process to record everything, the information is available. Secondly, it is common practice, as was done here today, for a committee chair to allow external recording. We have news outlets who television comes periodically to the legislature. Committee chairmen are asked, they grant that. So I really felt that both the material would be available, and we already have a process for doing that.
The fact that you have to ask to do it presumes that at some point the chair is going to say no. If you added it to 884, it would remove that presumption that somebody could be stopped from having public access to public meetings.
Happy to have further conversation about that.
Okay. Once again, part of a very exciting negotiation that hopefully one day scholars will write about. I will entertain a motion to pass AB 844 to Senate Appropriations Committee.
With all of its flaws, I'll move the bill.
Okay. So Senator Liu moves, do pass the Senate Appropriations Committee for AB 884. Would the author like to close?
I think it's been said. And we will, if this moves forward, and which I would appreciate today, it does provide opportunity for continued dialogue and discussion with the interested parties. I'm happy to be a part of that.
Okay. Thank you, Assemblymember. Thank you to the two of you. Secretary, please call the roll.
Motion is due pass to Senate Appropriations Committee. Allen?
Aye.
Allen, aye. Anderson?
No.
Anderson, no. Hancock? Aye. Hancock, aye. Hertzberg? Aye. Hertzberg, aye. Liu? Aye. Liu, aye.
Okay, so that passes out 4-1. Thank you, gentlemen. Really do appreciate it, and good luck with your negotiations. Let's take a
And we'll see that you get a copy of the
Please
transcript of
appreciate
your
that. Thank
meeting
you.
today, as agreed.
let's take a 2-minute break while we wait for the next author to come. I think we're
Move the consent calendar.
yeah, but
Still take